Okay, we're going to get started. Hi, everyone. I am Jamal Greene, Columbia Law School. This is a panel that I think is ostensibly about sensitive places doctrine, sensitive places, which you've already heard about some today, and comes from originally from District of Columbia versus Heller, and is one of the categories of exception that that the Bruen majority did talk about some, and given the way in which New York in particular responded to Bruen, it's a very live issue to try to think about how the court will think about sensitive places going forward. Not all the papers are precisely about sensitive places, but I sort of think of this panel as basically a continuation of the previous panel, which is trying to get at some kind of methodological and doctrinal issues that follow from Bruen. So we have Joseph Blocher. Darrell Miller is not going to present a paper, but is going to look pretty. Jake Charles from Pepperdine, and formerly at the Duke Center for Firearms Safety. And Adam...
Law. But
law.
We're
okay.
in favor of safety as well. Yeah,
that's and Adam Samaha from right here at NYU Law School. And with apologies, Reva Siegel was supposed to be on this panel, but she fell ill in ways that I think are not permanent. But she couldn't make it today, so that's also sort of an apology for the mantle that we have going here. But sometimes fate intervenes. So what's going to happen? We'll hear from the people who wrote papers. I will pose some questions. They'll respond, and I think if we have time, and we may not, but if we have time, it'd be great to get some audience Q&A going as well. So I think I'm starting with Jake, I think, and then going to Joseph, and then going to Adam.
All right. Thank you, Jamal, and thanks to NYU and the Duke Center for Firearms Law for hosting this. This is actually a jointly authored paper between the three of us, so I'll be talking a little bit about it, but if you have questions, direct them to those two. So first, how do we get the sensitive places doctrine? So Jamal mentioned that we got it from Heller originally, but what Heller said is simply that it was not calling into doubt certain long-standing laws like those regulating guns in sensitive places, and it listed schools and government buildings as two examples. That is the extent of what Heller said about it. Didn't say anything about that these were historically justified or any other rationale for why these kind of laws were going to be okay. All it said is we're not calling into question those types of laws. And lower courts since then have tried to determine what that means and why we are allowed to restrict guns from certain sensitive places. And then we get to Heller, we get to Bruen from last June. And what Bruen says about sensitive places is interesting because, as you heard earlier, the Bruen majority did not cite these other exceptions. It didn't cite this exceptions paragraph from Heller that blessed certain kind of gun laws. Instead, it did repeat this notion of sensitive places, though, being an exception to the right to keep and bear arms, maybe a scope exception. But it listed a different set of sensitive places than Heller did. So it listed legislative halls, courthouses, and election precincts. So it didn't say schools and government buildings. But it also gave no rationale or justification for why these places were sensitive places where guns could be prohibited. Instead, what Bruen said is this is an example of the ways in which courts can use analogical reasoning to justify new and different kinds of gun regulations. And so Bruen's test is we look to history and tradition to set the scope of the right, and then we reason by analogy from that history and tradition. And so how do courts do this? So let me just read an example from New York responded to the Bruen decision by enacting a sensitive places law, and that sensitive place law bars guns in churches or religious assemblies, any schoolroom or other place where persons are assembled for educational, literary, or scientific purposes, or from taking guns into a ballroom, social party, or other social gathering, or any other public assembly. So that's broad, and it sounds like a lot of places and like a lot of burden. That's actually not New York's 2022 law. That's an 1870 law from Texas. And so when courts are doing this kind of analogical reasoning, they have to look at these kind of laws. This is 2 years after the Supreme Court has said the Second Amendment is now applicable to Texas, and Texas is saying these are the places that we think we can restrict guns. So courts looking at this historical precedent will have to say, what are the rationales for doing that? Because what Bruen says look to is burden and justification. What's the justification for states doing that? And what kind of burden is it imposing on your right to keep and bear arms? So what New York actually did was bar guns from places like parks and sidewalks, Times Square, restaurants serving alcohol, daycares, hospitals, and many other places. But it has historical precedent like these laws that were in Texas in 1870. So our paper is a cautionary piece, and I'll just say one quick word on it. And it is an argument that courts ought to pay attention to these rationales and the justification when they are doing sensitive places analysis and developing the doctrine. But they shouldn't fall into the same pitfall as courts fell into with public forum doctrine in the First Amendment, which is looking to the places first and justifications later. But it should instead develop these justifications, determine what are the reasons why we can bar guns from certain places, more attention to the sensitivity than to the locations. And scholars have begun to work out some of these justifications. So some say that whether there's security in a place is determinative of whether or not the place is sensitive. That would provide alternative safety that a gun might provide. Other scholars have said the risk of danger in a particular place because of congestion, or the fact that there are vulnerable people there, like children, or the fact that it's a place that facilitates the exercise of other constitutional rights, like rights to free speech or rights to voting. And so our goal is to just have a caution that courts should pay more attention to those and not do what we've seen in the first post-Bruen sensitive places doctrine case, which has happened in the Northern District of New York, where what a court said was, look, Heller said schools and government buildings. Bruen said legislative halls, voting places, and courthouses, and that's the extent of sensitive places, right? It didn't do any kind of justification or history to look for that. And so we think that's an important thing that courts have to do as they're developing it, not just look at a list of places and see which ones are individually justified, but develop a theory for why these places are places we can restrict guns.
Thank you.
Cool. Thank you, Jamal, for moderating. Thanks again to the editors for putting together this really, it's been a fascinating discussion so far about how Bruen has changed really the landscape for Second Amendment doctrine going forward. The paper that Riva and I are working on is a paper about a way in which that is quite literally true, that is with regard to the landscape, which is what Bruen says or doesn't say about the justifications for sensitive places restrictions, as Jake was just setting up. On the one hand, Bruen makes those restrictions much more practically important, sort of on a front-end, back-end kind of a way, to go back to Cynthia's remarks from the last panel. And also because Bruen gives us this new test, this historical analogies test, for evaluating their constitutionality. Now, I think there are lots of different ways to understand Bruen's test. There's lots of different, Bruen applies, as my count, 3 or 4 different versions of the test. For the purposes of our paper, we're going to focus on, as Jake just did in his comments, the sort of why and how, that is the justifications and the burdens analysis. And on that, in just very brief remarks here, I just want to make a couple points. The first, on the why, on the justification for restricting guns in sensitive places, I guess our first point is that the why goes beyond the preservation of individual physical lives. That is, the government's interest in keeping people alive and safe from physical harm is undoubtedly, I would call it compelling interest, historically indicated, but it's not the only interest that's served by gun laws in general or by sensitive places restrictions in particular. And Riva and I have shown in prior work the ways in which the common law history that Heller drew on and that Bruen seems to approve actually also recognizes the government's interest in regulating weapons in ways that protect people from intimidation and terror, and in various ways, we argue, sort of protects the predicates of shared common civic life. And in sensitive places restrictions in particular, that may mean preserving the physical public places that comprise a community, that are themselves the predicate for a democracy. A second point is that once we understand the sort of why of the original sensitive places laws to include, but not be limited to, this sort of protection of democracy and prevention of terror and intimidation rationale, it's clear, and this is building off what Jake just said, that the rationale extends to more places than just the ones enumerated in Heller and Bruen, because democracy happens in places outside legislatures and courthouses and polling places. It can happen in public assemblies. It can happen at a July 4th parade. Consider what would happen, for example, if Highland Park were to reenact as it actually has already, a restriction on, let's say, AR-style rifles at its next July 4th parade, given what happened in Highland Park this past summer. That, we think, would be a preservation not only of physical lives, but a preservation of the community's valid interest in being safe from terror and intimidation, and in coming together in democratic solidarity. So that's a couple brief thoughts on why, and I'm happy to talk more about how the history, we think, shows those interests to be indicated. The second is just to mention the how, the burden side. And this is actually, I think, sort of a difficult problem maybe to think through in the particular context of sensitive places restrictions, riffing off of some of the stuff Eugene was saying on the last panel about burdens being relevant to whether and how the Second Amendment is implicated. It's tricky to think about how that works in a sensitive place, because the nature of a sensitive place restriction is essentially to render armed self-defense illegal in that space. That is, the burden, in one sense, is total within the space. You're not allowed to bring your gun into a legislative assembly or a courthouse. The burden sort of goes through the roof there, and yet, as Jamal said in his introductory remarks, Heller, Bruen, McDonald, a variety of lower court cases have said sensitive places restrictions are okay. So it must be that even a very high burden, an absolute one if you like, can be tolerated in certain situations. And again, the historical record, I think, shows this. Sensitive places restrictions, some of them are quite large and were absolute. One example of this is the tradition of preventing guns in schools, not just sort of K-12 schools where people will be coming during the day, but places where people might have been residents, which was, essentially imposing a large burden on them. And courts, historically, including places like Texas and Georgia in particular, upheld those restrictions, and essentially in doing so characterized the gun owner's interest in carrying a gun into those places as minimal. That essentially that no person would validly have an interest, a valid constitutional interest in carrying a gun into a courthouse, into a legislative assembly, into other forms of sensitive places. As Jake mentioned, covered much more than just the short list that Bruen gives us. So broadly speaking, I think the historical record gives robust support for government's authority to restrict weapons in order not just to preserve lives, but to preserve democratic functioning. And I'll just end with one sort of cautionary note, which is where our paper ends, which has come up throughout the day, but I think is worth putting on the table for the sensitive places discussion, is that it's hard to apply a principle that so closely ties the scope of modern gun rights to American history and tradition that is so rife with racism in gun law enactment and enforcement. And actually, the Supreme Court's own Second Amendment jurisprudence, in kind of interesting ways, establishes that not only is there systematic racism in the regulation and use of firearms, but signals the court's willingness, at least the justices in the majority, I presume all the justices, to take account of that, and in kind of an odd way. That is, the justices in the majority in Bruen and also in McDonald seem to believe that when enforcing the Second Amendment, the record, the historical record that is, should be judged according to modern standards, at least when it comes to expanding gun rights. That is, we can sort of carve off historical examples that are themselves infected with history and yet yoke ourselves to those, to the historical silences. I think that's problematic. Now, it may be that the court is only willing to repair race equality in the record, in the historical record, in a way that is expansive of gun rights, but at least without further evidence to the contrary, I think we're ready to assume that the court's professed commitment to race equality in guns could work in both directions, and one way that might cash out in this historical analogical approach would be, for example, to give extra weight to the historical examples, and there are some, of governments, for example, in Louisiana and Texas, using gun laws, including sensitive places restrictions, particularly to combat racial inequality. Louisiana has a law we cite in our paper that imposes a half-mile sensitive place restriction around voting places in the aftermath of Reconstruction. So I'll stop there and happy to talk more in the Q&A.
Thank you, Joseph. I'll give it to Adam.
Thanks, Jamal. Thanks for inviting me. Let me know if you have trouble hearing me on the microphone. So my paper is a little more broadly methodological. The starting point, though, is not sensitive places, but licensing. And the starting point question is, why isn't all firearm licensing unconstitutional? Because it's not. Not after Bruen, because the court took care to make a distinction between may issue and shall issue regimes. Now, why is that? Do you know the answer? You don't know the answer, you got to read the paper. Okay, all right, well, so first of all, Bruen's general methodological commitments might appear relatively narrow and tight, at least in contrast to the Court of Appeals decisions that they meant to repudiate in the majority coalition, and at least at first look. But at the same time, even the majority's proffered considerations were broader and looser than just some narrow version of plain text and old historical examples and analogies there too. And this was partly, but not only, to accommodate shall issue licensing. Okay, I want to bracket for now non-legal considerations. Everyone knows that could have some influence in judicial decision making. And also whatever appears in a judicial opinion or other written explanation from a government official is not necessarily, in fact, it can't really mirror all the considerations that somebody's engaged with. And what appears on paper might not be a consideration. But I want to bracket that, though, and try to take seriously the public logic of the court's reasoning and try to understand why they drew this line, and then make a couple of broader methodological points which we might take up in discussion. Okay, so first I want to just flag that the apparent foundation of the text plus history, and with the concurrence by Kavanaugh and Chief Justice Roberts, probably post-enactment tradition as well, the foundation for that is supposedly judicial precedent. Let's just note that first. And then why develop precedent in that direction? Well, here you don't often get any kind of explanation, but in cases like Heller and Bruen, the majority is suggesting, well, it's actually legitimacy plus what courts are good at, expertise. Now that's already a pretty wide range of considerations as the foundation for the test we're now supposed to operationalize. Okay, so now beyond that though, that alone isn't going to distinguish may issue and shall issue. The way the court dealt with plain text in Bruen, which has something to do with the who, the weapons, the conduct proposed, there's no basis for distinguishing may issue or shall issue there. The court just tells us they don't see a distinction between home possession or use of firearms and the public. When it comes to history, the way the majority opinion, Justice Thomas's opinion, uses those sources, well, from what I can gather, and Saul Cornell and others are here to know more, there was zero firearms licensing per se in the United States until some cities in the very late 1800s, and then some states in the 20th century. And worse for the distinction between may issue and shall issue, may issue regimes seem to have emerged earlier in that timeline, not later. So older is supposed to be better in constitutional analysis. Seems like the suggestion should be the opposite. The may issue should have a better claim to some sort of historical pedigree. And then in terms of whether these examples are analogous enough to shall issue, well, these analogies that might end up being a pretty flexible form of reasoning, all kinds of distinctions might be made, but the reasoning that the majority coalition actually gave us doesn't really offer a lot of friendship to shall issue. They distinguish the Northampton laws and the surety laws not apparently on vagueness or official discretion, but instead on their narrowness toward terrorization and to some sort of individualized suspicion with respect to the arms bearer. And those kinds of concerns seemed equally applicable to may issue and shall issue, maybe even worse for shall issue. Now there's post-enactment tradition, which I'm pretty sure Justices Kavanaugh and Chief Justice Roberts are interested in, but there once again, it's hard to use tradition to justify either one of these forms of firearm licensing. I don't know, maybe a 20-year tradition of apparent domination by shall issue is enough for a tradition, but I'm really not convinced about that. The other part of the problem here too is that there's a constitutional carry position that's emerged in about half the states. So a lot of states have shall issue as an option, but for a class of firearms carriers, no obligation to try to seek a license. And for unexplained reasons, the court didn't seem interested in that comparison, that more recent development. Now, the court also points to contemporary popularity. It's not, they don't devote as many words to it, but it actually appears in more than just a footnote, but also in multiple places in the majority opinion, and also seems featured in the Kavanaugh concurrence. So that is a potential way of trying to defend shall issue over may issue, but I can't think of another consideration that is more distant from text and history and tradition. That's a 21st century kind of development. So maybe, again, that could be a foundation. And then there is a subtle, it's sort of shy, almost embarrassed footnote about please don't take what we're writing to call into question the shall issue regimes. And here I have some agreement with Eugene Volokh from earlier this morning. That language in that footnote, I think, is easily translated into modern doctrinal terms like vagueness, overbreadth, and dare I say it, means ends tailoring. So the majority wants to disparage that kind of logic, and they don't use the labels, but when it comes down to trying to give some initial reasons why they're going to preserve shall issue, it seems that what is familiar from doctrinal buildup in some other areas of constitutional law seems to take hold. Okay, now I'll just quickly raise a couple of broad methodological questions, which I'm still trying to work through myself. And these aren't challenges just for the majority coalition in Bruen, they're equally challenges for the dissent and really for all of us. And that is, given this range of apparently legal considerations in shaping the decision of the court, as I've framed it, what's the relationship among these considerations? What's it supposed to be? A little more specifically, are all of these considerations constitutional in stature? Or are they a mix of non-constitutional and constitutional considerations? Now, if they're all constitutional considerations, one might think, well, that's a really wide sweep. And now I'm not so sure there's a difference between constitutional logic, non-constitutional but legal logic, and just extra legal logic, normative reasoning of other kinds. Now, another possibility is, well, no, we'll tighten up the range of what's a constitutional consideration, and maybe that could be any subset of what we've been discussing. It could be maybe just text plus history, for example. Maybe that's the best way to try to understand what the majority is doing here. But if we do that, then we'd have to recognize that almost all the analytical action for preserving shall issue licensing would then be in the non-constitutional domain. And that would, I think, undercut our sense that constitutional argument is somehow special and superior, tight, narrow, and also supreme. And if either way, whether these are all constitutional considerations or a mix of constitutional and non-constitutional, that produces this challenge. Sometimes we think of it in a related framing as a law politics kind of challenge or relationship. But this is a law relationship, constitutional to non-constitutional, but nonetheless legal reasoning, and then how that might implicate non-legal logic and the sustainability of constitutional argument over time. So I'll just end there by saying that this isn't meant to be some special challenge for the justices who built up the Bruen majority coalition. In a way, it may be a special challenge for them because they do seem to be at surface level trying to suggest a narrowing of the considerations that are eligible in resolving these kinds of cases. But ultimately, it's a larger challenge for all of us, whether it's possible or in what form can we sustain constitutional argument, analysis, and decision-making such that it's both special and unique. And if we can't do that, then it might help us question the place and even the domain of constitutional law in our legal system and our society more broadly. So thanks for your patience.
Thank you to all of the presenters. These are really great papers. They're relatively short, but I learned a lot from all of them. I'm going to just put a couple of sort of questions / comments to each of the presenters, and then just give a chance for them to respond, and then afterwards open the floor to people in the audience. And so first on Jake, and this is Jake and Darrell and Joseph, since you collaborated on the paper. this paper has the feel of kind of looking for a grand deductive theory of sensitive places, or what is it that justifies this particular category in order to be able to develop it further doctrinally, which makes sense. So just a couple of questions on that. So one is the degree to which it's really intelligible or possible to do that in this particular space. Sometimes we do just have ad hoc lists of things, and we kind of make do with that. And maybe part of the problem here is that you have complete and utter opposite views about what makes something a sensitive place, right? So if one side of a debate thinks a place is sensitive because there's a high risk of catastrophic violence, and therefore you should be able to regulate firearms in that space, and then someone else says that's why you can't regulate firearms in that space because I've got to arm myself in response to the possibility of catastrophic violence. So that seems to me irreconcilable, and so there's not really any possibility of theory to drive that category. Question mark, is that right? The second point is to ask whether there may be somewhat more inductive ways of doing this rather than theorizing from the top down, which is to say, we might think of the sensitive places inquiry not as capturing some particular set of justifications, but capturing a broad range of justifications that may interact with each other, may not necessarily, may be independent of each other, so that maybe we can think about this particular doctrinal category in terms of a set of rules and a set of standards that are driven by a set of necessary, sufficient, necessary and sufficient, or neither necessary or sufficient conditions. So you might think, well, it's one necessary condition is that a sensitive place has to be exceptional, right? It can't be something that swallows the whole rule, which I'm going to ask you about in a moment. It can't be something that swallows the whole rule. One sufficient condition might be it's a government building, maybe. There's probably nothing in the both necessary and sufficient category, but that can sort of generate a set of rules. So if it's a government building, if it's, is it exceptional, yes or no, and then that gives us some traction. But then as to the other sorts of things, like is it densely populated, are there children present, and so forth, those might be kind of a totality of the circumstances, where you're looking at none of those things is sufficient, but if several of them are present, maybe that's relevant. So is that a plausible methodological approach? To Joseph, on your paper with Riva, so I'll just start with the same question that I started with on the other paper, which is about the possibility of consensus. Where here I'm even more worried about the sort of under-theorized agreement around democratic governance, which is a very broad category, and one where people who are proponents of gun rights say guns are a necessary condition to democratic governance because it safeguards their autonomy in some way, enabling them to participate in democratic governance. And then the case for going the other way is obvious and laid out in the paper, which is it can feel threatening to people and so forth. So you have sort of the same problem. And this particular category, unlike sensitive places, really does seem like it can swallow sort of everything. I mean, every public space, I can tell a story about it being relevant to democratic governance. And so I'm trying to figure out what doesn't count along these lines. And so wouldn't any community after Highland Park be able to say, look what happened in Highland Park? we will be traumatized. Obviously, it applies to them, but it applies to everyone, right? And it applies before Highland Park because it's not, you don't need Highland Park to make that leap, which then leads me to a kind of broader question about the paper's, the agenda of the paper, which is, and also leads to a question about what the agenda of, let's say, a lower court judge should be. Because I detect in the paper maybe some discomfort with Bruen. And so in light of that possibility, you know, do you see what you're doing as being faithful to Bruen? And by extension, do you think the lower court should be trying to be faithful to Bruen, assuming the premise that they think Bruen is a mistake? Or is it sort of legitimate to say there are ways of being kind of subversive and slipping in proportionality or balancing analysis that Bruen wants to reject, but saying, no, actually, if you really, there's a way of reading this where you can actually put this kind of analysis in there, and if you're someone who wants to kind of pull back and moderate the court a little bit, you should take advantage of these possibilities, which is a slightly different, where that's not faithfulness, that's trying to undermine the case, but using the hang it by its own petard sort of thing. So just sort of generally curious about that as a broader point. And to Adam, I in typical fashion of reading an Adam paper, which tends to be very thorough, I had a hard time, of course, in my role, I'm going to try to say, well, here's a way where actually, you actually can articulate some traditionally constitutional principle that can distinguish between shall issue and may issue regimes, and it's hard to do that. Fair enough. But so here's my stab at it, which actually connects the paper to sensitive places, in the sense that sensitive places shows up on what seems to be a sort of ad hoc list of rule-like side constraints on the right to bear arms, and some of those side constraints have to do with what sorts of people can bear arms. Are you someone who has been convicted of a felony? Are you someone who's mentally ill? We can all pick at those categories in various ways and say why they don't really fit, but they're there, right? And so as a matter of precedent, you've got to develop those categories in some way. Is there a way of saying we're attentive to who is the person who is bearing arms, and so that leads you to shall issue, but also may lead you to may issue. But we're also sensitive to the idea that these are side constraints and they have to be rule-like, and so and may issue doesn't look like a rule. It looks like your cost-benefit analysis is sneaking in, and that's bad. So that's my effort. On the broader methodological point, I want to try to add a wrinkle to this interesting point about constitutional versus non-constitutional considerations, and just see if you think I'm onto something, which is that maybe you talked about constitutional considerations as if they're something higher than non-constitutional considerations, but maybe we can, and so we should be troubled maybe by significant overlap between the list of the menu of constitutional considerations and the menu of non-constitutional considerations, all of which are legal, as you say. But what if we think of constitutional considerations as not as higher, but as resting within a different kind of institution, right? So it's just, judges, when they refer to certain kinds of considerations, they become kind of constitutional considerations because judges are special, not because the considerations are special. In which case, we shouldn't be so bothered if they seem to be referring to the same kinds of considerations as other actors might within the system. What might follow from that, by the way, is that there may be constitutional considerations that are special to other institutions, but not to judges. I think of Justice Jackson's dissenting opinion in Korematsu, right, where he's like, it's not none of my business whether you think you need to defend the nation here, but if it's in my court, then I've got to say that you're wrong. And that's just saying the constitutional considerations are specific to the institution. So I'll stop there and give a chance for people to respond.
So, can everybody hear me okay? So let me try to field at least the first part. Obviously excellent questions and really thoughtful ones. Appreciate the engagement with the papers. So let me try to answer the first part of your question about Jake and Joseph and my paper, which is about the kind of mechanics, like why, are we advancing a theory that is really about deductive reasoning rather than inductive reasoning? And what I would say is that I think that we're sort of acknowledging that these things will probably, just through the mechanics of litigation, take place in parallel, but that too much focus on, again, the sort of noun of places rather than what makes them sensitive is the hazard. Now, how is this hazard going to be avoided? Well, as we say in the paper, the process that the court has offered in the Bruen case by reasoning by analogy requires, as everybody knows, some sort of rule of relevance, right? So, one sensitive place is not going to be like another sensitive place just because both are made of bricks, right? It's going to have some kind of rule of relevance that the court is going to have to identify to say this is relevantly similar to this other kind of sensitive place. And that will become the sort of kernel of this notion of sort of a set of theories about what makes places sensitive along the lines of what we've talked about. The other thing that I think is important here is that courts are not the only actors in this space, right? Legislatures are also, whether writing legislation or defending legislation, are going to be in the business now of articulating the reasons why they think some place is sensitive. And in some ways, they are channeling through a set of sort of first-order thoughts the intuitions of people in those communities about why, for example, it would feel weird for a gun to be in a, an operating theater, or in a daycare or something like that, right? And so the way that the legislatures end up articulating why they've designated these places as sensitive and then defending them then becomes grist for the mill of these kinds of, deductive principles that make places sensitive that then get fed back into the common law adjudication case by case.
Yeah, let me just say, in terms of your comment about we might have these intuitions that push in the opposite direction, I think that it's really interesting in Justice Alito's concurrence. He says, the state and the amici say we have this crisis of gun violence and a proliferation of guns. And he says that is exactly the reason not to restrict guns, because that's the reason why people want guns, because we have gun violence and a proliferation of guns. And I think that gets at the heart of this tension in sensitive places doctrine, because the reason for the protection of the right to keep and bear arms, says Heller, is for armed self-defense. And yet to have a sensitive places doctrine is to recognize that there are at least some places where guns are not making us safer, are making us more dangerous, or are inhibiting other rights or interests in ways that we find problematic. And so there's, to justify the right to keep and bear arms as useful for armed self-defense with a sensitive places doctrine, I think is really difficult, and why we have courts and scholars having this disagreement about underlying justifications. I agree with you that I think it's not going to be there's not going to be kind of one justification that fits all places that might qualify as sensitive places, but that courts are going to have to abstract from a case-by-case analysis, that there's not going to be, we're going to look at a daycare individually and see if there's a historical analog to daycares, that they're going to have to find some principle that underlies the restriction of whatever places we did it in the past and why that might justify or not justify daycares today. But overall, I think you're right that it's going to be a totality-like test, and it's going to be one that ultimately is derived from case-by-case application, and we're just urging courts to not just nail down and do one place at a time, but figure out what these justifications are that are going to be helpful for other cases going forward.
I just want to ask, just clarify one point, because we've said on a number of occasions, both Joseph and Jake, about sensitive places is kind of a paradox because you don't have a gun, and I think we're all in agreement that the ordinary rules of necessity that would override any other sort of legislative prohibition would take place here. That is, if somebody was, it was a necessity that you ran into a sensitive place with a gun to stop a mass shooter or something like that. We're not talking about that would be, a prosecutable offense in any way. And this sort of saps the problem that Joseph, is still lamenting about in Heller, which is about the rules about safe storage, and the court says, well, the safe storage law is unconstitutional because it doesn't have any express exception for self-defense. But all laws have necessity exceptions, and so we're not saying that none of these sensitive places doctrines wouldn't have the ordinary necessity defense if you end up using it.
Which, I mean, is in a way just a callback to Cynthia's work. I mean, it's a way that's what I think Cynthia's working on. It's what Eric Rubin has worked on in prior papers, is the intersection between the Second Amendment and self-defense doctrines. And there is a moment, I think, clearly in the sort of life of a defensive gun use, at least one that involves pulling a trigger, where the Second Amendment just ends. Like, the actual pulling of a trigger, I think, is governed by doctrines that don't have anything to do directly with the right to keep and bear arms, because pulling the trigger is neither keeping nor bearing, it's something else. And that's where self-defense doctrines will kick in. Absolutely, necessity, justification, all that stuff should work. So just two quick thoughts in response to really, really hard questions, Jamal. On the first one, I think to our sort of collective project here, I do think rightly that sensitive places doctrine will end up being kind of a mix of kind of rulification and principles and reasoning. I think, and that's always the case in in any area of developing doctrine. I think what it feels like to us that there's a particular risk here for mistaking the outcomes for the reasons, and actually we're already seeing that in the Northern District of New York case you already heard mentioned earlier today, the first one to opine on the constitutionality of New York's sensitive places law. The judge there said, and I had in front of me here a minute ago, that Bruen effectively rules out any sensitive places beyond and then lists the 5 that are mentioned in Bruen, and that's just wrong. I mean, that's inconsistent with how Bruen actually reads, but it is, I think, mistaking the places for the reasons. And I think here, maybe in more than I think in other areas of gun law or maybe other areas of constitutional law, the sort of reasons for justification are tailored in a very weird way to the actual spots. Like, they'll be litigated as places, like post offices or Capitol Hill or whatever, but what makes a particular place sensitive could be so temporary and so evanescent. Like, a place could serve as a polling place one day a year and be sensitive just for that moment. How you define that, how you treat that is I think tricky. They're incidental in some respect. On the last of your questions about my paper with Riva, and our failure of poker face, I guess here, to demonstrate our belief in Bruen. I am uncomfortable with the methodology of this opinion. That probably does come through in how I describe it, and certainly how we write the paper. I don't think that it gives proper guidance to courts, lawyers, scholars, people trying to understand the scope of their Second Amendment rights. I think methodologically it just doesn't work very well. But this is an effort to try to work within what Bruen says and use the grammar as it says. And if that ends up being a sort of hoisting on the petard, I'd certainly be okay with it. But I think what we want to show is, look, what Bruen tells us, and this is building on actually point Mark raised on the prior panel, if Bruen gives us this historical analogical test, and one way to understand it and one way Bruen states it is that you look to the how and the why, then an easy way to kind of break that down is, okay, I have to compare a modern law to some historical, historical law or practice or whatever, across 2 metrics: how the law burdens people's right to self-defense, armed self-defense, and why it did so, right? That requires like a historical how and why and a modern how and why. And in order to do that, to just do the comparison, on the modern side, you're gonna have to show and know things about how gun laws work in practice. Like, what is the burden on a person's right to self-defense, to echo Eugene's point on the prior panel, if they have to substitute some other weapon for a high-capacity magazine or an AR-15? Is that a negligible or essentially non-existent burden? If so, then there's no work happening on the burden test. And so what we're trying to show here, I guess, is that with regard to sensitive places, if you're looking at the historical and the modern why, one legitimate why is the use of sensitive places to protect democratic functioning in particular places. Now, it is a good question of, like, how far can that go? And Bruen tells us that sensitive places can't be invoked so as to eviscerate the right to self-defense. That's how the court characterized New York's defense of the public carry restriction that it struck down. And that, I think, is historically indicated as well. So an aggregation of sensitive places could cause a problem, especially for a gun owner who has to pass through lots of them, and like, well, then I can't carry my gun at all if I can only carry it in the places in between. Like that I think is how we should be approaching these issues, is sort of like the aggregation within a sensitive place, again, with the exceptions for self-defense, which come, or necessity and justification, which come not from the Second Amendment, but from common law or self-defense law. I think within the sensitive place, the burden can be total.
Thanks. So consistent with what Joseph said, because it's a Jamal Greene set of questions, are deep and difficult, so I'll give my first reactions to them. My responses, I guess, have two subheadings. One is about old method, and one is about ordinary method. So on the rulification idea and the problems of official discretion, that is one way of making the divide. I think it's consistent with what the majority opinion said, and it seems to be very old and not toward the mission, if it is one, of tightening and narrowing legitimate constitutional method, at least in this domain. So that seems old and therefore broad in a way that sets up one of the potential dilemmas, which is, well, now if it's broad, it might be ordinary. And then that relates to this other point you made, which was, well, how about thinking institutionally, which is a great idea. And there's no doubt that within courts, they develop some subset of considerations that are somewhat special to them. Maybe more importantly, there are a variety of institutional constraints that make their reasoning different, participation within those institutions different than, say, the Senate or Office of Legal Counsel and the Department of Justice and so forth. And that actually helps explain this district court opinion in New York. There just isn't a whole lot of capacity to do the exhaustive research and analogical reasoning. So they'll be looking for a chart a little like Eugene Volokh produced, but instead, like more granular. So all that's okay and helpful. It's just that there, I think I can repeat the challenge of whether the reasoning, the activities are not ordinary, whether they're not becoming more ordinary in the sense that recognizable and shared across institutional boundaries. And while that can make courts more accessible to more of us, especially non-professionals, it becomes harder and harder to defend the institution as supreme in any important way, I think. Now, maybe all this will just depend on results, case level results, like the chart I was just referring to. But to the extent it depends some on how people explain what they're doing to each other, I think I can repeat the challenge, but in maybe a more refined way. Thanks, Jamal.
Thank you to the panelists. And looks like, is that a hand, Barry? If maybe you can go to the microphone that's next to you. It may be a longer journey for others, but Barry's right there anyway.
I'm right here. So I thought it was a great panel, and there's just been a question that's bugging me since the symposium began, but your panel is the most apt, which is, I can't read all of your excellent papers and think anything other than the reasoning in Bruen about how we're just going to look to history and we're not going to look to means ends analysis is anything other than, to use a very technical legal term, crap. Because everything that justifies something being a sensitive place ultimately has to involve a government interest. I can't understand that test any other way. And if that's true, then we're doing means ends analysis at some level. And I found most peculiar the idea that we would actually look to an 1870 statute to understand what's analogically apt. where there's clearly a government interest there, but so the government interest in 1870 matters, but not the government interest now? I mean, I just can't make any sense of that at all. So maybe all of you can help me.
Well,
Bruen defender. Go for it.
well, okay. So, so the least charitable answer is, yeah, it's crap. You know, this is a lot of hand waving. You know, to be a cultural warrior to come to a certain conclusion, and that's all that Bruen is. But we're lawyers and we're legal academics, and we believe that there's law somewhere in this room, and so we treat Bruen and we treat Heller and we treat these other opinions as if there's law somewhere. And so, where's the law there? Well, I guess it's in a couple places. One is, I think you're right, it's just that now the means in scrutiny is kind of sort of baked into some kind of analog, right? So the version that we think of it, like for dangerous persons, is you've got an analog, historically, quite grotesque, in fact, about who the founding generation thought were dangerous. But you have a concept of dangerousness. And then you have regulations to keep guns out of the hands of dangerous people or in places where they're going to be dangerous. And then you look at the analog and you say, I mean, you can do it just sort of categorically and say, is this like a school, or is this like a government building, or is this like the kind of person that we have thought of as dangerous in 1791? Or you can say, no, the real thing that we're trying to find is dangerousness. And then that's where this kind of means in scrutiny just comes in, not on its own, on its own steam, but basically baked in this sort of analog package. And so you're explaining the reason why we're regulating this now is because the principle is dangerousness. How do we know they're dangerous? It's because of this cost benefit that now takes place in this kind of roundabout way. It's inefficient. It doesn't make any sense. I kind of think it's likely to happen, and the reason why I think it's likely to happen is because we're already seeing the lower courts sort of shrug and say, I don't know how to do this. You're asking me to do this analog thing with limited resources, but I do know how to do this kind of weighting and tailoring and looking at empirical evidence and making some judgment there. So I think that as a matter of inertia and comfort level, there's going to be a certain portion of the lower courts that'll end up doing it. It's just going to have to be articulated differently.
It's okay if I make just a couple quick points. So I think on the surface level of the opinion, if we understand the decision as about licensing, it's got means and tailoring analysis. It's readily recognizable to me. Once they've defined a legitimate, I'd call it a regulatory interest, about picking out those who are not ordinary law-abiding citizens. Okay, but that inquiry could be anchored to an honest historical or traditional inquiry. And there I think the majority opinion is kind of atypically mature about analogical reasoning in that it recognizes anything can be compared to anything else. So we need metrics, and there's even a citation to a scientist, Barbara Spellman. They know that there's some problem with analogical reasoning. It needs to be guided. And it seems to me, in a way, they're taking a bit of a gamble and taking it in terms of its public reasoning, that directing attention to a certain set of source materials from about the late 1700s to the Gilded Age will have an influence on reasoning and outcomes, understanding that analogical reasoning needs some other logical engine to drive it.
I would just add on to that. I think I agree with Adam that the majority recognizes the problem, and it's nice that they do cite Bobby Spellman, who's written fantastic work on this. But I don't think they resolve the problem. I don't think they actually do provide the principle. Like, the thing that needs to happen next is, well, how are we supposed to compare? And the principles they come up with, why and how, are just different ways of saying ends and means. They have to be laundered now through a historical test. I don't know what it's going to mean for case outcomes or the styling of the way judges write their opinions, but I think unpredictable in terms of outcomes and weird in terms of opinions. I mean, I don't think, for example, that a court is going to strike down the federal law prohibiting possession by those convicted of domestic violence crimes, but they're not going to be able to uphold it based on pointing to a 1791 or an 1868 law. They're instead going to jump up a level of generality to dangerousness or something like that. But that's going to mean invoking or pointing to as I think reprehensible, whatever the history, how you described the history, pointing to a history which is, well, who did they regard as dangerous in the founding era? It was Native Americans, Black Americans, people who refused to take loyalty oaths. Like, what a weird way to write opinions. I do think the unpredictability point is the other thing here. I think that many judges, most, are going to fall into that camp, but there are going to be others who are going to say, like, I don't see a historical record of, and Mark mentioned this one on the last panel, depriving indicted felons or people who've been indicted for felonies of their guns, right? So 922N or whatever that law is unconstitutional. I was following a case in Michigan which involves a zoning restriction about shooting range, and the judge there had asked for, like, well, show me the historical record for using zoning laws to keep shooting ranges out of residential communities, and of course there isn't one because they didn't have zoning laws. It doesn't make sense, right? And so that's where I think it's just so hard to know where everything's going to go. It's going to be. We'll have to have another one of these in a couple of years to resolve everything.
A couple of months. Professor Levinson.
Yeah, I think this is a terrific panel. I want to pick up on Jamal's comment, but also what several other people have said. That is the issue of good faith and our role as lawyers or law professors. It does seem to me that the suggestion is that as law professors, lawyers, our duty is to be faithful mandarins to a court, whether or not we have any respect for what it's doing. And, I'm sometimes quote Felix Frankfurter in 1939 when he said, our loyalty is to the Constitution, not what judges have said about it. Now, in another context, I would be glad to talk about loyalty to the Constitution per se, but it does seem to me that when Joseph says you have discomfort with, well, I have discomfort with Brown. I think it's almost impossible to teach, but one can say that it is a great decision nonetheless in terms of its vision for the country, and it is indeed a wonderful function of the legal academy to try to work out what the rather confused vision of inclusiveness in Brown might be. That's not my view of this case. And it really does seem to me that we are called upon to say that, quote quote Antonin Scalia, where in Obergefell he says, my colleagues aren't really behaving like lawyers, which I think raises extremely interesting questions. Is this opinion so bad that we should not try to present it in its best light or to, rehabilitate it, but really to point out why it is dreadful in all sorts of ways? And, I think that's a real problem because, those of us who teach law get paid very well to try to make sense of Supreme Court decisions, and especially to say, look, you're going to have to litigate this stuff, and whether or not it makes any sense. You've got to go into a courtroom and talk about sensitive places. You've got your client who can benefit from one reading or another. This is what lawyers do. I agree with Darrell. You can't avoid that. Lawyers live within a certain confined system, but law professors are very peculiar lawyers. We're not litigating. And so how do we address and assess a decision like this?
I mean,
Into the breach once more, Darrell.
so I take your point, right? We're lawyers, we're law professors. Some of us are still members of the bar, so we're officers of the court, all that kind of thing. So there's, as with any kind of social movement, there's the inside game and there's the outside game. The inside game is how you explain within the confines of whatever the discipline you are. And I'm a law professor. That means I'm also a lawyer, so I have to make sense of Bruen on its own terms and criticize it using the tools that I can criticize it with, that I think that lawyers understand. There's the outside game, which is, and, I'm also a citizen of the United States, and I find, X, Y, and Z morally reprehensible. I'm not making a legal argument. I'm making a moral argument. It's morally reprehensible. I'm not going to say that about Bruen. I think it's a bad decision. I don't think it's morally reprehensible like, Dred Scott is, or Korematsu, or any of these other cases. But I will say that then I'm Darrell Miller, citizen of the United States and concerned citizen, and I make those kind of arguments. I always come back to the line from A Man for All Seasons, which is, I kind of do think that you have to give the devil the benefit of the law, because where am I going to turn when all the laws are cut down?
I'll add just very, very quickly. I think like what Bruen gives us, if anything, is just to borrow a Sandyism, like a grammar, to make these arguments in. And this goes back to Barry's question as well. And we're trying, I guess, to operationalize that. It's interesting to think about the aftermath of Heller, when you had, as you wrote about at the time, like this, more than 1,000 cases decided before the Supreme Court really legitimately got involved again, trying to resolve essentially, concrete cases without a whole lot of guidance methodologically under Heller. And it may be that the courts will look at Bruen and say, like, we just can't do it. This tool doesn't work. And so they might continue to, as some lower courts already are doing, cite the the Heller exceptions paragraph, which after all, Kavanaugh and Roberts put into their concurring opinion, say, you know what, the good old time religion is still good enough, and we're going to keep sticking with that. And I should say, since I know we're closing, for anybody who wants to keep this conversation going, I can plug the event next week, yeah? Levinson Fest? Google Levinson Fest, because some of us at least will be talking about Sandy's contributions to this field on 2 o'clock Eastern Wednesday, I think, for anybody who's Google it, and you can register and come on and hear more of this, since I think we're close to time.
I can just take a few seconds. Thanks. So in this particular project, I'm not trying to put the decision in its best light or its worst light. I'm also not trying to fit it together into some seamless web of legal development either. I've done quite a bit of litigating in my time. I still think it's okay to look at decisions this way, and at the same time, try to facilitate practice of law, as in wealth and analogical reasoning. People are going to have to struggle with this, so let's see what we can do. One point that's interesting about this decision, and Heller as well, is that they are starting to point to the foundations of the methodological choices that they're making. And that helps open a broader conversation that practicing lawyers often can't really get into, which is, how did you choose the framework that's now going to become part of our conventional law, however ragged at the edges or indeterminate in many applications it might be. And that can be a great foundation for teaching without, or maybe in conjunction with, recognizing on-the-ground consequences that could be deeply concerning.
And with apologies to other hands, I'm going to keep the trains running. And please join me in thanking our panel.